Thank you very much and good evening. Justice Upadhyay, Honorable Chief Justice, Justice Jingan, Justice Jyoti Singh, Justice Tushar Rao Gadela, thank you for taking this initiative, sir. I think it was much needed. Justice Hari Shankar and Justice Pratibha M. Singh. The list got a little bit shorter. I hope the subsequent speakers don't have to take fewer names. My friend Hari, also here. Thank you for coming. We are going to get into a little bit more of a meaty discussion of what pleadings look like. I do have a lot of slides, and I thank my junior Ananya to make these slides for me and not using much of AI, I hope. So thank you for that. But we're going to get into, I'm going to be covering trademarks and copyrights with the caveat that I have not drafted a pleading in many, many years, but it has been one of the most enjoyable experiences when I was not a senior advocate to draft pleadings, and I found that to be one of the most fascinating parts of my practice. And the other part of my practice is now to look at really sad pleadings and then go and argue the case to the best of our ability. So I miss that part. So anybody who thinks, who's not enjoying drafting pleadings, I think it is the most exciting part because you create that story. And I couldn't agree more with Sandeep that creating that story in a short form and putting it precisely is always a challenge, but a challenge that we must overcome. And you brief anybody in the Supreme Court and they'll say, if your synopsis your first page of the synopsis don't catch the bench, before you can say Jack Robinson, they'll be dismissed. Thankfully, we are a little more liberal in the high courts where there needs more detailed pleadings and more detailed orders. So this is just broadly the overview. I'm going to run through most of these slides because there are many. Ananya's being very, very kind on making too many slides, and the reason for that was that Justice Gadela told us that these will be uploaded, so you can see those slides later on, so I just covered most of it, but this is going to be the overview of my discussion, and I really want to get quickly onto the meaty part of the plaint itself. Cause of action, gosh, I even can't read these. I need my specs. So just quick overview on what the Supreme Court has said on pleadings, how meaningful they need to be. Give it a quick read because I don't have the time to go through these. There are many of these. The cause of action has to be a real cause of action. You need to base that to form your jurisdictional clauses, your pecuniary jurisdiction clauses, your territorial jurisdictional clauses. And of course, that forms the core of a pleading, that you must have that cause of action to come to court. The plaint has to be a self-contained document containing all the facts. It must not have clever drafting. These are some broad principles that courts have set out, so I thought it would be helpful to set them out for the benefit of all the audience here, that the plaint is your Bible, and you'll find it very difficult to go beyond the plaint eventually if you get stuck on any point. So make sure, and here I think there's a challenge between prolixity and brevity because there's a lot of time, and I'm going to discuss that as we go forward, of non-disclosure. And so how do you make a full disclosure and yet be brief in your pleadings? Again, just some findings of pleadings and how mere exercise of semantics, having a real cause of action. Many judgments have discussed cause of action as being an important element of pleadings. So again, cases, I'm just going to run through them. You're going to have the benefit of seeing them online, so I thought it was just helpful to put all of them. I didn't delete any of these slides, but generally gives you a good overview of what the judgments are. These may not be, according to my friend Sandeep, the latest ones, but I thought my slideshow is not that. Then comes an important factor, and the main case of Chengalavara Naidu, which we cite it often, and there is a sequence of cases. The Supreme Court really sets out that you are really in a contract with the court to give it all the facts truthfully and honestly. And in IP law, you will find that that becomes very, very important because it is an ex parte ad interim based jurisdiction. Earlier it used to be an injunction based jurisdiction, but today the battle on the field is mostly ad interim injunctions, which have been either obtained or denied. If they have been obtained on non-disclosure, And you can imagine that if you've stopped somebody's business to a grinding halt without a full disclosure, and this is where I think the challenge comes about as to how do you disclose, because mind you, a 200-page plaint with every disclosure possible is also not appropriate disclosure, because surely you're not expecting a judge to read through 200 pages. And if your counsel has not stood up and pointed out to paragraph 252 and 563, which were the main disclosure points, I would call that non-disclosure as well. So to write paragraphs and paragraphs of disclosure in several paragraphs of other nonsense, if I may say so, which is beyond the cause of action, is probably a challenge that courts should look into. That pleadings need to be precise, but yet disclose every aspect of it. These are some of the mandatory provisions of the CPC. Order 6 we've spoken about. Order 7 is return of plaint. And Order 7, Rule 11 is rejection of plaint. Return dealing with, again, IP has various ways of now incorporating jurisdiction. And because the Delhi High Court is at the forefront of IP jurisdiction, our councils and courts have attempted to keep jurisdiction as much as possible, or there are lots of disputes over jurisdiction. And clarity on jurisdiction is very important. I remember arguing a case where a plaint was returned on forum non-convenience, where a court said that you are better off in another court because that is where another litigation was pending, and that is the more convenient forum. And the argument really was that shouldn't there be clarity on which court the plaintiff can go to? And if the plaintiff is to take that decision and is the dominus litis, if you start applying the principle of forum convenience, then one court may find court A to be convenient, whereas another court may find a court B to be convenient, and a whole jurisprudence may develop on forum convenience. And before arguing my injunction application, we will all be arguing on the aspect of jurisdiction of the court. Thankfully, the division bench agreed with me and passed an order saying that if in CPC forum convenience has no place, if the court has territorial jurisdiction, it must necessarily decide that dispute in that court. It can't send you to another court which may have concurrent jurisdiction. These are some of the mandatory provisions of the CPC, which in Juhi Chawla, one of the courts, discussed this in detail. Again, I invite you to read this because the court did set out and gave us some direction of what pleading should really look towards. I'm again not going to read all of this, but you're going to have the benefit of, but it is a good judgment to read the various provisions and what need to go into those provisions for a well-drafted plaint. Just some light thrown on that. Again, this case continues, discussing in detail, so I invite you to go and see this as 2021 DHC 1823. Then essentials of a plaint. And this is what a plaint should generally have headings and subheadings. It should talk about the parties, briefly about the plaintiff. If it's a trademark infringement suit, and I'm talking trademark infringement stroke copyright, I'm not talking patents here. There are several other speakers on that subject, so I didn't touch that topic. Prosecution history has become an important element because certain statements are made in prosecution history. And again, I was before a bench, and the discussion was that, are you serious that, and the normal argument here is that some junior lawyer may have said something in the prosecution 20 years ago. Is the plaintiff going to be bound by that statement made to the trademark office? And that was something that concerned quite a few courts and said that doesn't sound right, that if some junior said something about a trademark in a particular context to the trademark office, that the defendant is now going to cite that in its prosecution history and say you ought to. But I think the fact remains that perhaps that history would have to be disclosed, and it's becoming a more and more of an important factor, because unlike in the past, where you had to browse through records of the trademark office, and whoever went to the trademark office in those days, you wouldn't want to touch those files because they had 2 inches of dirt on them. But now they are all available on your computers online, where you can search the prosecution history. And the first thing that a defense counsel does is goes and looks at that prosecution history. It must have, as use of the mark, if it's in copyright infringement suits, then comparison of the marks. Sandeep spoke about actually showing the 2 marks. So putting the 2 marks, if it's a visual mark, is always helpful. Then there's previous litigation, which is again a disclosure requirement. The cause of action, jurisdiction, court fee, prayer, sign and verification, statement of truths, which is a requirement under the Commercial Courts Act. We'll dig deep into these. Generally, the parties, we tend to write a lot about the plaintiff. We tend to write a lot about the defendant. Why? Because the judge should know that I am not a fly-by-night operator, and the judge must know who I am. So at least 10 paragraphs are spent, I've noticed, as a general concept, about the plaintiff who has there's no concern with the trademark at issue. I think this could be concise to 1 or 2 paragraphs, a little bit quickly about the plaintiff. I'm in the top 100, top 200. I am my leader in the field that you're necessarily talking about. But we talk pages and pages, perhaps to impress our clients and build them higher, to say, look what I think of you. You may not think of that, but at least the pleadings think of that. And mind you, this is way up front. This is very important. You're writing about the plaintiff way up front, so by the time that you've come down, the judge has come down 20 pages of the plaintiff, he's lost interest in the case and said, you know what, I can't go on with this plaint, next matter. Then it continues history, background of the plaintiff, nature of goods. I think it's good to put it. You can't avoid it because you can't assume that the judge knows the plaintiff, but in most cases, if it does, 1 or 2 paragraphs does a good enough job. Now, registration details, I think we should set out very clearly. I've noticed in many cases, registration details, the goods are not mentioned. The classes may not be mentioned. The trademark itself is not set out. You say X, Y, Z, but whether it's a word mark registration, it's a device mark registration, what exactly is that registration? This matters. It is 1 paragraph, but it matters. What are the goods? And I would highlight the goods that are in issue in the present proceedings, because your registrations may go well beyond what is required in the suit, which is ABC goods, but you want to tell the judge fairly, but goods are normally not mentioned. I know this takes up space in the plaint, but goods must be mentioned. Disclaimers must be mentioned. If there are disclaimers in a registration, those are often not mentioned, and the certified copy is produced, and the judge is expected to go and see the disclaimer, and especially if the disclaimer is relevant. Limitations and conditions of the registration are usually not mentioned. I think this, in a practice direction, must be set out that in a plaint, this bare minimum requirement. Now, prosecution history, what all should prosecution history have? Section 9 objections. How did you deal with those Section 9 objections? Because distinctiveness of your trademark is an important issue that the court must know. Section 9, to the extent of, is it acquired distinctiveness, inherent distinctiveness? Section 11 objections, were there other citations? How did you deal with those citations? The strength of a mark will depend on the space around it, whether what and how did you deal with this before the trademark office. And I think it's necessary to disclose that. Were there oppositions? Did you successfully? Often I find plaints which just mention victories in court, but don't talk of the losses. You've got to be fair, and under the Commercial Courts Act, you've got to mention every aspect of what is in your favor and what goes against you. So you must mention prior litigations, prior oppositions, whether favorable or unfavorable. And I think these should be mandatory heads in a plaint which should set out no oppositions ever filed, no Section 11 objection, no Section 9. You must be asked to disclose when your registration happened, what happened to these objections. Maybe the registrar didn't raise a Section 9 objection, so it should say nil so that you applied your mind to it. So a guideline, to my extent, I've been speaking to Justice Gadela on this, that a guideline like this must be set out so that, and I think one of the challenges when we are having discussions on doing this seminar, one of the challenges for a judge is to where do I find the material facts? So if there is a preset format which I think should work at, and we invite the bar to help us out doing that, is to preset that formula so that there's an index and then the court knows where to look for what particular fact which the judge may want to read about it before coming to court. This is just a case on prosecution history estoppel. That prosecution history will haunt a plaintiff for the long time. Justice Jyoti Singh said this in a judgment, and I couldn't agree more. Haunt or help you, but it must be disclosed, to my mind. Then comes use of a trademark. Again, this can be very, very long. What is the use? The most important fact in the recent Supreme Court judgment in Brehans is set out. You need to put out your sales figures. You need to support that with a CA certificate. I don't think you need to file all your invoices, but a few supporting invoices help. Some promotion, what is the extent of your promotion, which in the publications but you can't be writing pages and pages of the extent of use. I think this is where brevity has to come in, that you can file more documents. I know it's a passing off action and the court would want those documents and you've got to file those documents upfront. But I don't think you need to file your invoices if there's a CA certificate, which should be tested. If the defendant wants to test it, you should be invited to support those documents. But there's an expectation that the CA has gone through those documents and given fairly those sales figures. Similarly, you can put out all your ads, but then you can put out that the same ad appeared in 20 other newspapers. You can list those out in the list of documents, but not in the plaint. Copyright infringement suits have their own requirements. I just spent 2 slides on this, which is to the extent that how did you create this work, who was the author of the work, and how did you acquire those rights. Those are normally not given. I'm the owner of copyright, whether it's a sound recording or an artistic work or a book. How did you acquire these rights? And most of the times the plaintiff is not the author, and therefore the requirement to lead up to who was the author, and registration is not a requirement. So copyright is that unique animal where registration is not a requirement or even helpful. So you've got to disclose in your pleadings the entire sequence of what exactly is the work, no exaggerations, and be more precise on the type of work. Then about the defendant, again, I think brevity can be an aspect which can be introduced here. We don't need to write, and we tend not to write too much about them. Most of the defendants that I come across are fly-by-night operators. So what if it's a large corporation, but mostly they've just launched day before yesterday, so we don't have much to say about that. But I think there has now become a requirement, again, under headings. Did you conduct a trademark search? What were the keywords that you searched for the defendant's trademark? Did you go on Google and other social media sites to see? Did you go on and check when the first social media post was posted of that particular defendant? Or are you going to make an off-the-cuff remark that you just knew it day before yesterday because you were not expected to see when he first launched his Facebook page or Instagram page, which may be 5 years old, but I missed it and there was no requirement for me to see it. I think there needs to be headings. Did you see the Instagram, Facebook, X? You say no, no, nil, nil, nil. Yes, first date, Facebook was this date. Hence, what is the basis? I think here we need a little bit less brevity and more explanation, what all searches were conducted. And some judgments have discussed search being a prerequisite and an essential requirement. Then comparison of the marks should be visual if there is visual marks. You must specify, I think, in A, B, C, or D. Are you talking of identity of marks? Are you talking of phonetic similarity? What are the areas which are common to trade? What is it that, which parts are you considering as dominant parts of the mark? Where are you saying that anti-dissection? Anybody who's familiar with the law, you'll need to read up the law and really express to the judge what is it that you are trying to ask the court to look at. Are you trying to say look at it overall? Are you trying to say there is a dominant part in that mark? Why you should look at that part? So I think we need a little bit more explanation here because the entire case revolves around this determination. Then previous litigations, this is the kind of disclosure that is required. See, I've already talked about it. Cause of action, again, I've just discussed it. When did that cause of action arise? What was the basis of that cause of action? Et cetera, et cetera. This needs to be a little bit more detailed. At least 2 or 3 paragraphs should be, setting out the details of when that cause of action arose. Territorial jurisdiction, the famous Ultra Homes case, gives that additional forum. If you are claiming it under that forum, read this judgment very, very carefully in Ultra Homes. It was very, very succinctly put out how and when the court would have jurisdiction. I think it was a beautiful chart that Justice Badadure Amos put out in this judgment. Helpful. Then court fee and valuation. We tend to include nowadays, especially on online disputes, a lot of defendants. There can also be multiple plaintiffs. Look carefully at how you value your order to rule 2 is an important consideration for you to see whether there's joinder of cause of action, misjoinder of parties. You need to look into those aspects, and you've got to pay court fee on each aspect of each plaintiff connected to each defendant. It should total up to 2 crores. which I'm told will now stay at 2 crores. And we request the Honorable Chief Justice to look into that and ensure that that stays at 2 crores. Because we are a premier court and we don't want to lose any litigation and continue to be premier in that respect. Prayer clauses again tend to be very, very long. Try and put the first prayer to be your concise prayer. Courts tend to. And now here again, I've seen a lot of mischief of the first prayer having something way outside the court, and the courts don't tend to. Sometimes the judge misses it, the counsel deliberately doesn't point out, and you get a prayer granted to you which is way beyond the plaint. And the poor defendant has to suffer that injunction for the longest period before he can have it vacated to say the prayer itself was mischievously drafted. I think is something that we need to be very fair. And sign and verification, I'm not going to trouble you with that. Statement of truth, written statements. I think I'm way out of time because there are lots of good speakers. I don't want to eat into that, but this would be uploaded. There's lots of good stuff here. Admission denial, you know of these documents. As I said, there's too much to cover, and I think I'm way over time, so I'm not going to take up more time because I know there are excellent speakers following me, so I don't want to hog up the time. But thank you very much, and let's work to making sure that this court continues to be the preeminent court, and as bar and members of the bar, we must assist in that exercise and ensure that our judges don't feel that we are eating up time of this court, but every time that we come out to argue, those arguments come into good judgments which we are all proud to quote all over the country, all around the world. And I think we all owe that duty to the court, and I think we should work towards that. And again, requesting that the jurisdiction remains the same. Thank you.